The good member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. I'd like to move adoption of Amendment 1678.
It has been moved and seconded that Amendment 1678 be adopted. Remarks, Representative Walsh.
Thank you, Mr. Speaker. One of the complicated and troubling elements of the underlying bill here and of the Voter Rights Act in general is a shift in the burden of proof when wrongdoing in an election process is alleged. In effect, Mr. Speaker, what the underlying bill says is if a local jurisdiction is engaging in any change in their process of how they vote, whether it be a redistricting or a procedural change, they are presumed guilty unless they receive a document called a certification of no objection. I spoke before, Mr. Speaker, about an M.C. Escher drawing, a process in which physics doesn't seem to apply properly. There's a bit of that here, too. Mr. Speaker, as you well know, in our laws, in our traditions, in this state, and in this country, a person, or in this case, a local jurisdiction, is generally presumed to be innocent until proven guilty. But the structures of this proposal do the opposite. They require the local government, the local jurisdiction, to get this letter, this certification of no objection from the state attorney general before they can proceed with any change in how they manage their elections locally. Mr. Speaker, I believe a presumption of guilt in just about any context is wrong and is fundamentally unjust. What this amendment does is it straightens out that twist in the normal jurisdictional processes that we have in this state. And it allows the local jurisdiction to be presumed innocent, and only if the Attorney General, the State Attorney General, can show there's something wrong would the jurisdiction need to get this permission to change their election processes. Please vote yes on the amendment to make the process more rational and just.
The member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. An essential amendment, I would say. I've spoken before about one of the problems in the underlying policy being the shifting burden of proof, that you have to prove yourself innocent if you get engaged in one of these disputes. Mr. Speaker, combine that with the exposure that a local jurisdiction has without this amendment to potentially unlimited legal costs. And Mr. Speaker, as you've heard in other contexts too about this underlying bill, this practically invites the weaponization of the underlying policy. Mr. Speaker, we need balance in these voting rights laws. And when you tilt the scale, when you tilt the mechanics too much in one direction toward organizations or even the office of the State Attorney General to be able to litigate these matters with a stacked deck in their favor and no recourse for the local community to get whole, you have a situation where the mere threat of litigation by the State Attorney General or others under this bill will chill, it'll have a chilling effect on reasonable adjustments to local districts, local elections, local voting practices. And Mr. Speaker, I'm sure that's not the intent. But we see unintended consequences all the time. And in this case, the chilling effect will tend to keep those that are down, down, and those that are up, up. They call, Mr. Speaker, as I think you know, this concept where a loser pays on legal fees, they call it the English rule. And there's not a lot I like about English rules, but this one I think is just. The loser should pay so that there's not a perverse incentive to chase frivolous actions under the State Voting Rights Act. It's fair. It's just. Vote yes on the amendment. Thank you, Mr. Speaker. Good amendment. Please vote yes. I'll just add quickly, Mr. Speaker, this is another element, well, that is the issue in the underlying bill that this amendment fixes, is another element in the potential weaponization of this public policy. If the Attorney General or anyone else can keep coming back to a local jurisdiction frequently, even after an issue has been resolved, that's going to be another tendency toward weaponizing what is a well-intended public policy point to try to prevent manipulation of local election practices. Mr. Speaker, when you take these several elements of the underlying proposal together, you see a formula that could be directed at one local jurisdiction over and over and over again with immense risk to the local jurisdiction and very little risk to the prosecutor. It's not balanced, Mr. Speaker. It's not fair, but this amendment does make it a little more balanced and a little more fair. Please vote yes.
Representative Walsh.
Thank you, Mr. Speaker. Good amendment. Please vote yes. Article 1, Section 2 of the Washington State Constitution is the Supremacy Clause. It recognizes that the U.S. Constitution, and by extension, federal statutory laws controlling over our public policy here, when they are in conflict, our state policy yields to the federal. That's the gist of the constitutional issue in this proposal. Please vote yes.
Further remarks. The member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. Good amendment. Please vote yes. Mr. Speaker, Charles Dickens' first great novel was The Pickwick Papers. And that novel involves a decades-long, generations-long lawsuit. Mr. Speaker, I believe without this amendment, the underlying bill will discourage local jurisdictions from settling these disputes and create an atmosphere in our state of generations-long litigation. We don't want to discourage the rational settlement of a Voting Rights Act dispute. We want to encourage that. That, as most of our law does, well, when it works, encourages efficiency, encourages resolving differences without getting involved in Pickwick Papers' never-ending litigation. Without this amendment, local jurisdictions facing ruin because of a weaponized attack on their local elections processes may decide, well, we're damned if we do, we're damned if we don't. If we settle this, we can still get dragged back into court, so we're just going to fight forever. That's not good public policy. That doesn't do anything to make elections fairer and non-discriminatory. All it does is enrich attorneys and enrich bureaucrats who service never-ending legal action. And, Mr. Speaker, from an economist's perspective, that's moral hazard. Avoid it. Vote yes on the amendment.
The good member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. I'd like to move for adoption Amendment 1676.
It has been moved and seconded that Amendment 1676 be adopted. Remarks, Representative Walsh.
Thank you, Mr. Speaker. The underlying proposal includes a newfangled term, citizens of voting age. Mr. Speaker, in the context of the Voting Rights Act, this phrase, citizens of voting age, I believe has worked to the detriment of fairness and justice and good, reliable elections. Mr. Speaker, Article 1, Section 2 of the U.S. Constitution is the part of the federal Constitution that talks about the census and populations and how populations are counted as part of the census and then used for districting and redistricting and other purposes. Now, Article 1, Section 2 of the U.S. Constitution has had some bad language in it in the past, some things we no longer consider good law and really never should have considered good law. And the sections of that part of the U.S. Constitution have been raked over many times for well, almost 250 years. But with clarity, that part of the federal Constitution says that what the census counts is the people of an area, not the citizens of voting age, but the entire population. And Mr. Speaker, what our local state Voting Rights Act has done is it has incorporated this different term, citizens of voting age. Well, the citizens of voting age are not the same thing as the population of a city or a county or a legislative or congressional district. Mr. Speaker, you and I don't represent citizens of voting age. We represent all the people of each of our respective legislative districts. And what this amendment does is it removes this newfangled legalism, citizens of voting age, and uses the term that our federal Constitution and our state Constitution use to describe who our constituents are, and that is the people. It's fair, it's just, and it cleans up a legalism in the underlying bill. Please vote yes on the amendment.
The good member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. Again, I believe that this good amendment, so vote yes on it, prevents the creeping policy direction in the underlying proposal toward weaponization. Mr. Speaker, if the State Attorney General or any other party involved in these protracted, long-lasting litigations wants to force another redistricting on something that has already been redistricted, that allows the prosecutor to basically check and recheck and chase around a district map an individual candidate or an individual trend that they don't like, frankly, and I hate to say it, for political reasons. It allows these prosecutions, it allows these legal actions to be directed in a way that is not just, but could be used as a way to try to tilt the outcome of specific elections. And my goodness, Mr. Speaker, that should be the opposite goal of what we're trying to do in a good and fair and robust Washington Voter Rights Act. It is not, I believe, the intended purpose of the underlying bill, but there it is, a kind of defect in the middle of the bill, and this amendment fixes it. Please vote yes.
Further remarks. The good member from the 19th District, Representative Walsh.
Thank you, Mr. Speaker. It's a good amendment. Please vote yes. Mr. Speaker, I encourage you to read Section 2 of the underlying bill. I've read it several times, Mr. Speaker, and it does not make coherent sense internally. I'm not even sure what it is trying to do other than create a period of uncertainty in which even a clearance letter would not be reliably a clearance letter. I don't understand how that is supposed to help a rational resolution of a disagreement over a local jurisdictional election policy change. Mr. Speaker, we need clarity in the law. We need clear lines of what constitutes compliance and non-compliance. And this section of this underlying bill does not add clarity. The amendment does by getting rid of the confusion. Please vote yes. Thank you, Mr. Speaker. Good amendment, which I believe is clarifying. It straightens out some pretzel logic and confusing language in the underlying bill. Mr. Speaker, in the underlying bill, only the local jurisdiction which has been involved in a dispute with one of these certifications of clearance is allowed to challenge a bad outcome from the State Attorney General or anyone else, but mostly the State Attorney General. Mr. Speaker, it's asymmetric. It's unbalanced. Various entities may be involved in creating a complaint under the underlying policy, but according to this section of the policy, only the local jurisdiction that has been accused can appeal, essentially, can challenge. And what the amendment says is that that limitation, that restriction, that prohibition on anyone else getting involved is lifted. And other people may intervene, other interested parties may be involved, and that adds balance back to the larger process in a lawsuit or legal action under the Voting Rights Act. So let's be fair, and if we allow other organizations to initiate an action, let's allow outside organizations who may have some interest to intervene to get involved in an appeal or pushing back. I think it's fair, and I think it also adds clarity. Please vote yes on the amendment.
Representative Walsh.
Thank you, Mr. Speaker. The mechanics of these actions, these Pickwick paper, these generation-long legal actions that may result from the underlying bill, one of the main problems in the mechanics of the proposal is you could come back again and again and again and essentially get multiple bites at the apple, get multiple chances to prosecute a local jurisdiction under the theories in the underlying proposal. What this amendment tries to do by removing some language which allows these multiple attacks is to say, really, if you've got a complaint, you can make it once. And I think that adds clarity and adds fairness to what the underlying proposal is trying to do. Mr. Speaker, as you've heard, and it's true, the mechanics of these actions are complicated. And I think we should take every step we can take to simplify and clarify them. And I'm not sure whether it's an unintended consequence or an intended consequence, and I'm not sure it even matters, Mr. Speaker. But the fact is that the mechanics of pursuing an action, as described in the underlying bill, are excessively complicated. And as other amendments I proposed have tried to do, this simplifies the mechanics a little bit. And it doesn't allow, and I'll keep touching on these same issues, Mr. Speaker, it doesn't allow a weaponized misuse of the underlying policy to attack again and again and again a local jurisdiction. I believe that the amendment helps make more efficient, and make more clear the goals of the underlying bill. Please vote yes on the amendment. Thank you, Mr. Speaker. Flawed bill. Please vote no. Mr. Speaker, the great science fiction writer Philip K. Dick wrote a famous book called Minority Report that they made into a not-so-great movie. But the book talked about precognition and how precognition was used to anticipate crimes that had not happened yet. This pre-clearance doesn't just sound like precognition. It is structurally like Philip K. Dick's precognition. It anticipates trouble that hasn't happened because of things that happened before that may have been litigated or may have just been settled because of previous litigation, and assumes that those bad things that happened before will happen again. Now, in the book Minority Report, Philip K. Dick's point was that precognition of crimes which had not happened yet was weaponized by a politically savvy, well, he wasn't a state attorney general, but a politician, to eliminate political foes that he didn't want to see have success. Now, I'm not saying that the underlying bill would be weaponized exactly like in Philip K. Dick's novel. But, Mr. Speaker, there are troubling parallels. I believe that this policy, although well-intended, doesn't balance the playing field. It turns our law into a weapon of selective prosecution and mechanisms so convoluted, so complicated, so internally conflicting that you cannot mount an effective defense once accused. I'll go in another literary direction. I'm sure you know The Scarlet Letter by Nathaniel Hawthorne. A scarlet letter judgmentally applied to someone and forced to carry on for the rest of her life. The weaponization of the public policy in this proposal could create a scarlet letter for local jurisdictions that will mark them unjustly for a quarter century.